amongst all of us. The first one is make sure you update your healthcare directives. You're under duress, emotional, terrible time, and you have to make life and death decisions. I had a vague idea of what Ed would tolerate, but no time to really think about it. Next were the funeral preferences. Again, Ed's famous line was, if I should die, well, sometimes there are no choices. We already, gotten the plot, and because I had done my parents' funerals a couple of years before. So that part was taken care of. We go to Christ Church. They were amazing. Liz and Reverend Amy made it so easy. Again, I knew what hymns he liked, and that made it a lot easier. But for my children who had no idea, I'm starting a folder with all those preferences and things to make it easier for them. We ran into another snafu. He wanted to have a plaque next to my stepfather's in the military circle at Ponte Vedra Valley. And of course, we couldn't find the discharge papers, the DD 40, whatever it is. What is it? 214. So the funeral home tried to get them. Finally, Quinn Shells, where we weren't going, reached out and helped get that. So we got the plaque, but several months later. My first trial was with Truist Bank. I did all the banking, set up the account. It was a joint account, and I did everything online. Ed wouldn't have known online banking from a loaf of bread. But the first time I went to access it, they wouldn't let me in. So I went down to the bank and said, I've got an issue. And they said, oh no, you can still write checks. I said, I don't want to write checks. I want to get online. And I didn't even know what accounts were on there or what the account numbers were. Anyway, I'm still working that out. I've double paid most things for 6 months now, but I think the light is at the end of the tunnel. I don't know if anybody else has run into that. I know that somebody ran into a problem with Merrill Lynch and access to the account. So it's a good thing to check early to make sure you have total joint access. Insurance. Life insurance, that was the easy thing. The kids got their checks, and they would accept death certificates online, but the long form. The other advice is make sure you get enough death certificates, short and long form. But when it came to car insurance and all that, USAA is what we use. And they said Lieutenant Paul's number had to be retired. Of course it did. I had to get all new insurance, had no idea what I was doing or how much was too much or too little. I think it's worked out now. Then of course it costs more, but that's just an interesting little fact. This is an important one. Credit in your own name. A friend who's here had a problem. She and her husband always had a joint card. And when he passed away, Visa cut her off. They would not issue a card because in the world of credit, she does not exist. The bank said, oh no problem, you can deposit $500. You may not take it out for a year. You may have $500 worth of credit. And if you pay on time, we will up that amount to $750. And after a year, you can get your $500 back. We won't live long enough to get high enough credit. But yet, if you're in college and have no visible means of support, you can have all the credit cards you want. It doesn't make sense, and we can maybe start a class action on ageism. Another little hiccup that I found, successor trustees. Our estate plan was really good, but my grandmother had set up this little tiny trust for the kids and me, and my father was trustee and Ed was co-trustee. Well, Dad died, and then Ed died, and we have no trustee. And the trust was in Arkansas, so now we have to go to court, is that right? Nope. We have to go to Arkansas, get the trust transferred to Florida, and believe me, we're going to have a lot of successor trustees. Make sure you all have lots of successor trustees. Another little sticky thing that I'm still working out from 2007 when my mom died, she had a little CD at Bank of America to get free checking. And that CD is still there because in order to get it, we have to go to probate. And it will cost more going to probate than the $2,000 to get it. So every year I sign a thing, yes, I'm aware that the account is there. So just make sure you have 2 people on that CD. Another one, trusts. When somebody dies, their trust goes from revocable to irrevocable. And you get to get 2 new tax ID numbers. And not only that, now you are obligated to send an annual report to the eventual beneficiaries. And they have 6 months, is that right? Mm-hmm. To contest it if you overspent or whatever. That was a surprise. Passwords. In our case, passwords weren't important because that didn't happen. For a lot of us, especially as the sole survivor, I have a lot of passwords, and they're all on my Apple iPhone and in space. Well, that's not going to help my kids. So, again, in the folder, all these passwords will be there for them. Medical records. Mayo deletes you the minute you die. If you want to find out your spouse's records or even to check on the bills, you can't. You have to go into the office and deal with it that way. Fortunately, Medicare and supplemental was good, and we didn't have any issue with that. Social Security. I have not dealt with that yet. I know one friend called and she got a phone appointment a month from the date she talked to them. I figure I'll just wait a little longer. What's the difference? And then since now I'm single, and I have 2 dogs, I saw Annie this week, and we made arrangements for the dogs if I should die. And we also made arrangements for advance directives for help, because she suggested that we send a letter to the plug pullers with our very specific wishes. There's lots more on your sheets that were handouts. There's some suggestions of documents you need more than the Navy DD, whatever that was. But now I'm pleased to introduce Annie Janoski with Fisher, Towsey, Lees, and Ball. Perfect, right? And she is my lawyer. My lawyer quit suddenly. So fortunately, Annie came to the rescue. And Annie has a special connection here at Vickers. Her grandmother was a resident, and she was one of our wonderful wait staff. And she went to Nice High School and then University of Florida, and then on to the University of South Carolina Law School. With that, I'm going to present Annie, who will help you get out of this mess.
Thank you, Vicki. Yeah, so I'm very excited to be here. As Vicki mentioned, I did work in the dining room. I was a waitress and hostess in high school and the first couple years of college. So if you were here from like 2003 to 2008-ish, I probably served you some food and drinks. And then my grandma, I don't know if any of you knew her, Ann Smedberg, she lived here for about a decade before she unfortunately passed back in 2022. But I love Vickers. I was telling Vicki and Dick were nice enough to take me on a tour of the new section a few months ago, and I went home and told my husband I had just toured where we're going to retire to one day. So he's as excited about that as I am. But I grew up out here in Ponte Vedra. Like she said, went to Nice High School and back now in Jacksonville. And I am an estate planning attorney with Fisher Towsey, the law firm. Some of you may have heard of it, but yeah, we have an office out here in Ponte Vedra, and we have one downtown. And yeah, I, wills, trust, probate avoidance, trust administration, that's what I specialize in. And I love talking about estate planning, so I'm very excited that you guys are willing to give me a microphone for a few minutes here, so hopefully it won't be too boring. And then so we're just going to sort of run through the slideshow that I put together just to get some of the basics out there for you all. And then I'm going to hang around for a little bit, so if anyone has any specific questions, just feel free to come up and chat with me. So, first lawyer thing, but quick disclaimer that this is based on federal law, applicable federal law, or Florida law. Okay, so some of this is some overlap from what Vicki said, but these are just some quick checklist items that it's important for everyone to do. Myself, my husband, and I do this every year as well, just to go over it. So, in our online generation now, passwords, you want to make sure that even something as simple as your cell phone, do you know your spouse's cell phone password? Do you know, does someone have yours? If you're not around for the facial recognition, then is someone going to be able to get into your phone if they need to? Auto payments. Make sure that someone knows what your auto payments are. I know at Vickers here, you probably have it set up to do that. And it might be, and I know Vickers is great about dealing with that, but if you have auto payments for anything else, like a car payment or anything like that, make sure that you know what they are, you have them documented so that someone can stop them, so that you're not, money isn't going out of your accounts after you pass. A very important item is to review your net worth statement, understand what assets you have, what liabilities you have, where they're located, and who owns them. So I think something that people don't realize is that whenever someone passes, the way that the asset goes to whoever your heirs or beneficiary are starts first at how they're titled. And so we'll kind of get to that later on, but whether they're titled in your sole name, in a trust, jointly with a spouse, jointly with children, that's where you start, and that is a very important thing for you to know, how everything is titled. So that way you can sort of get them into the appropriate buckets now before anything happens. A big one in Florida is safety deposit boxes. What people don't realize is that if someone dies and they own a safe deposit box and they're the only owner, you actually have to get a court order to get into that safe deposit box. So you can give someone access to your deposit box, but unless they're actually a co-owner on it, they are cut off whenever you pass, and you do have to get a court order. Banks are very strict about that. It's a big liability issue for them. So we've actually kind of seen people sort of move away from safe deposit boxes nowadays and either just have a safe in their house or something like that, because, kids come to us and they're not thrilled when we tell them they're going to have to spend, $5,000 or $10,000 to court documents just to get into mom and dad's safe deposit box where there's nothing in there anymore. So that's something that I like to point out to people just to make sure that you're aware of that. Real property, especially, Florida, we have a lot of people who come here for retirement because of the sunshine and the warm weather. But if you retain your residences from a different state, it's very important to know how those are titled and to probably put them into a trust or an LLC while you're still living. The reason is that if you die and you own real estate in your sole name in a different state, your children or your heirs will actually have to do what's called an ancillary probate, which is a whole separate probate in that state where the property is located, which is just a lot of time and a lot of money if you can avoid it up front. And then, so bank accounts, a lot of us fall for that, free checking account. And I think people honestly sometimes forget what bank accounts they even have opened over the years. And so it's good to kind of take stock. I say once a year, sit down, list everything that you have, and make sure that you're on top of it. Because it's really hard after someone has become incapacitated or after their death to go back and actually find those assets if we don't have a good starting place. Okay. And then also it's good to know if you have any outstanding debts or creditors, mortgages, any promissory notes, credit cards, things like that. It's good for us to know all of that as well. Okay. And some of these are, actually, I think, Vicki, you might have hit pretty much all of these.
Because I lived them.
You did. So we'll just keep that slide. Okay, so a big one that I always like to point out to people is whenever someone passes, you always want to make sure that you talk to the funeral home about whether they're going to notify Social Security of the decedent's passing. Usually they do. They do, like Twin Shawls, obviously they're a big one out here. They always do, they're very reliable. The reason is that it freezes credit after someone passes, so no one can, there are a lot of sketchy people out there, unfortunately, so no one can go and use a decedent's Social Security number to, purchase things, ruin their credit, all of that. I'm an estate planning attorney. I don't do litigation. That's where I have to pull in my litigation partners to go after, the bad people. And so it's very important to freeze someone's credit immediately when they pass, and typically that's done through the funeral home who notifies Social Security. As Vicki mentioned, also we usually advise getting at least 5 short form and 5 long form death certificates, just because banks usually need one, life insurance companies will need one. Sometimes we have to record them for real property transfers, so they're just helpful to have.
On the note with Social Security, they did pay Ed's October Social Security. They withdrew that so fast
Yeah.
that I don't think it even was stayed in the account 2 seconds and moved back out again.
It was there for a split second, and then it was gone. And then, the digital assets again, so, emails, bank accounts, subscriptions, if you have a Netflix account, anything like that, that are your online digital accounts, make sure that you have those listed and you have the passwords listed somewhere. Because again, those are all things that are usually tied to credit cards or can have personal information on them, and so we want to go and be able to close those appropriately whenever someone passes as well. A big one that people don't think about sometimes is actually changing physical locks on homes. I know here at Vickers this is a very safe place, but if you have any other property that you own anywhere, you want to make sure that you know who has keys, who has the alarm codes, access to security cameras for all of those properties. Because, part of your children or whoever your fiduciaries are, their job is to make sure that they secure all of your assets, and that includes any buildings or any property upon your passing. And, we all give out extra spare keys to friends and family over the years, and so it's just important. Most of the time we say just change the locks just to be safe, but always kind of good to know who you've given that access to. And then, of course, carrying out the funeral wishes, inform the military branches. I know my grandfather was in the Navy, and they're both buried up in Arlington National, and it was pretty quick with my granddad, but with my grandma, it actually took us 18 months to get a date to go up there and bury her next to my granddad. So, and I was with my mom and my uncle calling them every couple weeks to ask for updates. So, just something to keep in mind that can be a little bit of a process, and to make sure you've got kind of all the pre-planning done with those types of organizations. Cancel prescriptions, just to be safe. I always like to update that. The car title, so an important one is do not let anyone drive a car or really anything with a motor, so that includes boats, airplanes, any toys, quote unquote, with motors. If someone owns one of those types of things and they pass, if they're still on the title and someone gets into an accident, then it can put all of the decedent's estate at risk if there was a lawsuit. So we say, lock that car up, take the keys, hide them, don't let anyone drive it until it's either been sold or title has been transferred to whoever the beneficiary is of that vehicle or that boat, just to be very safe. So, and then of course, file any health insurance or Medicare claims to make sure that you're getting those full benefits as well. Okay, and then of course, you want to let you and your partner's attorney, CPA, financial advisor know when they've passed, so that we can start doing the items that we need to do to help. As Vicki mentioned, typically with most estates or trusts, you will get a new tax ID. Some of you may have revocable or living trusts, and so you know that you use your social security number while you're still living as the tax ID for your trust, but that does change whenever the owner of a trust passes and you get a new federal tax ID number for it. Again, cancel all the subscriptions, just silly things that magazines, things like that, those can all wrap up over time. Outstanding creditor, debtor information, and then we'll cover some of this, but for me, my job, a lot of it is helping with administering the trust, paying off final creditors, making all the tax items are taken care of, and then successfully transferring the assets to whoever you want them to go to, so whether that's family, friends, charitable organizations, schools, things like that. So a big one to remember is that a final income tax return does have to be filed for a decedent in the year that they passed. For a married couple, usually you can just file a normal joint return if you've been filing jointly. Otherwise, you do have to file, an individual one, and so usually we use your CPA or, whoever you've been using for taxes to do that. And then a big one whenever someone passes is their assets typically will get what's called a step-up in basis. So, I'm sure you all know about basis in an asset, what the value is, capital gains tax, things like that. So whenever someone passes, the basis of that asset, when it is transferred to their beneficiary, is typically the date of death value of the asset. So that's why a lot of people, will hold on to valuable real estate and not sell it before they pass, is to pass it to their heirs, capital gains tax-free. So the date of death value is normally used. There's also something called an alternate date or value date, where you can wait 6 months to value it. We don't do that super often just because you usually can't predict the future and people don't want to wait 6 months to transfer assets. But there are situations where it can be helpful, so that's just something you want to talk about with your attorney. And honestly, a lot of times we use the financial advisor and use their projections to see about that as well. And then Form 56, so if you have a taxable estate, which, again, there's a more detailed slide, but right now in the United States, the estate tax exemption, or the inheritance tax, as a lot of people call it, is $13,990,000. So that's the amount that you can pass during your lifetime, plus what you have when you die, to your beneficiaries and not have to pay any inheritance tax on it. If you have over that amount, then you have to file an estate tax return. The number for it is a 706. So that's just something to keep in mind. You have a 9-month deadline after someone passes to file it, and you can also get an extension for 6 months. Okay, so this is sort of my helpful chart. But as I mentioned, the titling of assets is very important, and I think a lot of times people underestimate how important it is when it comes to titling. So I just wanted to sort of run through the categories that we can have. So jointly held assets, so that's where you typically think, between a married couple or between, parent and children maybe, if they're adding them on. Those pass to the surviving joint owners whenever one of the joint owners passes. Assets with a named beneficiary, so that's usually your retirement accounts, life insurance, annuities, assets like that, pass to whoever your beneficiary designation is. It's important on those assets that you make sure you have a beneficiary, because it defaults to your estate if you don't, and then it has to go through probate. And unfortunately, we see that happen a lot. And that's usually just a really simple change of beneficiary form that you can order from the financial institution that houses, your IRA, your 401k, or what have you. Your last will and testament, so assets that pass via the terms of your will, is anything that you own in your sole name that doesn't have a beneficiary upon your death. And that's what has to go through probate. And probate is the court process in Florida that those assets have to basically kind of sit in limbo for several months before they can pass to the beneficiaries. There's a 3-month creditor period, there's filing fees, you have to publish in the local paper. So it can be fairly expensive, and it usually takes about 9 months to a year for that process to complete. And so a lot of what we do at my firm is trying to avoid probate using trusts, using beneficiary designations, and other things like that. And then intestacy is what we call it in Florida when you don't have any estate planning documents at all. So if you have no will, no trust, you technically have an intestate estate. And essentially the state has its own laws of where assets go. Whenever someone doesn't have a will or a trust, it's usually to the next closest relative. And in that situation, there's nothing that anyone can do to change it. It just kind of goes how it goes, and everything has to go through probate. And then if you have a trust, a revocable trust, or sometimes it's called a living trust, then of course it goes to the beneficiaries that you have named in the trust agreement. And then and all of those assets on the top part are includable in the taxable estate for purposes of calculating the estate tax that may be owed. And then, we do a lot of tax planning using irrevocable trusts, and some of you may already have these set up or heard of them, but things like life insurance trust, gifting trust, spousal lifetime access trust, and then a lot of charitable trusts as well. So those can be very helpful too. Okay. So, just a few really quick basics about wills versus a trust. So, a big point to know about a will is that it is recorded in the public records when you pass. So, anyone can go down to the county probate clerk's office and ask for a copy of anyone's will. So, if any of you want to know what your neighbor may have had in their will when they passed, you can go get a copy of it from the clerk's office. And everything goes through probate. You can include, really any provisions that you want in there of who gets it. In Florida, luckily, we have no restrictions on who you can leave your assets to. You don't have to leave a certain amount or percentage to spouse, children, things like that. You can do really whatever you want in your will. In Florida, we use the term personal representative as the executor or executrix down here. That's just a term that the legislature came up with about 20 years ago, and I know it's different in most states, so I always like to point that out to people because they're like, what's a personal representative? And I say, well, that's what we decided in Florida to do to confuse everyone, so. And then a revocable living trust is what we use a lot of times to avoid probate. So, I'm sure you run it or you may have one already, but a ton of people have them in Florida. They're really, really useful, flexible documents. So they come into existence at the time that they're signed, and then you put assets into them while you're still living. So bank accounts, real estate, stock, investments, corporate interests, all that kind of stuff can go into your trust while you're still alive. Another benefit of a trust is that it is a private document. It does not get recorded on the public records when someone passes. The only people who are able to get a copy of it are the successor trustee of the trust and the beneficiaries of the trust. So that's why a lot of people use them as well, as just for privacy matters. They don't want people knowing who their money is going to. So again, we use it to avoid probate by retitling assets. It's really similar to dispositive provisions as far as how you can set up an inheritance for your kids or your grandkids or charities or anything like that. And then once you have signed your trust, sort of step A is getting it in place. Step B is then actually retitling your assets into it. So, taking a copy of the trust to your financial advisor, to your banker. My firm, we help with a lot of the real estate retitling, the corporate interest retitling, things like that. And then really the goal is to have it all funneled into your trust, and then it all flows automatically to your beneficiaries upon your passing. Okay, and then some extra documents that they're referred to as ancillary documents, but they're very important on their own. So you have your power of attorney. So that's what you traditionally think of as far as who would be in charge of your finances if you're still living, but you're incapacitated. So, the two most common occurrences are if you're in an accident, you're in the hospital in a coma or just in bad shape, who would manage, pay your bills, things like that for you. Or, as we age, if you develop dementia or Alzheimer's, memory loss, that's who would manage your finances for you in that case as well. And then similarly, having the healthcare surrogate document, a lot of times we call that the healthcare power of attorney in Florida. So that's who makes healthcare decisions for you if you are not able to make them for yourself as well. And then the sort of end-of-life healthcare document in Florida, we call it the living will. So that's, as Vicki referred to, is the pull-the-plug document, quote-unquote. So that's, most commonly thought of if you're in a vegetative state, if you're only being kept alive artificially, two doctors determine that there's absolutely nothing that could be done for you. Then you name your trusted people to make sure that your wishes are carried out in those regards. We also have a pre-guardian declaration in Florida, so if you ever needed a guardian in the future, that's the document where you list who you would want, and essentially it keeps other blood relatives of yours that maybe you wouldn't want as the guardian from being able to petition the court to get guardianship over you. So that's an important one too. Okay, so this is where I like to try and scare people. So what happens if you don't have any estate planning documents? So while you're living, if you become incapacitated, so whether it's via an accident or just, as we age and we start to lose our mental capabilities, if you don't have your powers of attorney and healthcare documents in place, then you have to, your relatives essentially have to go through and get a court-monitored guardianship put over you. So essentially a judge gets to choose between your closest relatives who manages your finances and who manages your personal side. So who decides where you live, who your doctor is, etc. You will have no control over that at that point. A judge gets to decide for you, and the judge doesn't know you, so whether or not they pick the right person is a little bit of a toss-up in the air, unfortunately. It's also an expensive process. Under our law, you have to file annual accountings, you have to file annual plans, and a judge does have to approve any major distributions of assets out of a guardianship account as well, so it's very expensive too. At your death, again, assets pass via Florida's intestacy laws, and unfortunately no one can change that. So, spouse, children, grandchildren, in a very specific way. So if there's anyone else that you wanted to leave assets to, or if you wanted to leave them unequally or anything like that, we do have to do a will or a trust to make that happen. And then minor children or grandchildren or great-grandchildren, if you want to leave anything to a minor, if you don't do it via a trust, then again, similarly, it goes into a court-monitored guardianship for them as well, and their closest natural parent is the one who would have guardianship over them. So, an example that I've seen happen a few times where I've had a client come to me, their child unfortunately has predeceased them, they have grandchildren who are minors, and we have to put it in a trust because otherwise their spouse's ex-husband or, ex-wife, who our client doesn't like, would actually be in charge of their entire inheritance from our client via the guardianship law, which has caused many conflicts, as you can imagine. Okay, and then really just quickly on the estate tax. So the good news is that, like income tax, we don't have Florida estate tax, we don't have Florida inheritance tax, which is great. So we only have to worry about the the federal level. So again, right now it's $13,990,000. The current tax rate is 40% for anything over that amount. So I did just a really quick math problem, basically, where you can kind of see for yourself. So for example, if someone had a total of $21,990,000 between their lifetime gifts and what they had at death, that $8 million excess would cause a $3.2 million estate tax to be owed that their children would have to pay out of their estate. So it is a pretty high tax rate. That's why we do so much estate tax planning. Currently, under current law, it is set to drop at the end of this year. As of January 1st, 2026, under current law, it would drop back down to around $7 or $7.5 million per person. We anticipate, given the election results last fall, that may not happen. They may extend it, but no law has actually been put in place in that. Congress hasn't passed a tax bill or anything like that. I'm sure you guys have probably seen all the news about that lately. So we are still, running our practice under the assumption that it will be dropping. So we've done a lot of planning for our clients who maybe don't have taxable estates under the 13 million, but who would if it dropped back down to, 7 or so million, just to be very safe. Again, we may be in a use it or lose it situation, because this is the highest that the exemption has ever been historically. Okay, and then really, really quick, so just some examples of what you can do to lower your estate tax. So you can gift $19,000 to anyone that you want, absolutely gift tax-free. So, we have clients who every Christmas, they, give their kids and grandkids the annual gift tax amount. You can pay directly medical and educational expenses for anyone as well. So, if you have grandchildren or great-grandchildren who are in private schools or college, you can pay directly to that educational institution, and that does not count as a gift. Similar for medical, someone needs braces. You can pay that directly to the dentist, and that also doesn't count against your total. So I think those are two easy ways for people to really move money out of their estate that they might not realize, and to do it completely tax-free. Also, 529 accounts are great, again, for any young children who might go to college one day, and then a bunch of the different irrevocable trusts. Also, charitable gifting, if anyone is interested in that, there are a lot of ways that you can set up for charitable giving, whether it's during your lifetime now or at your death, using different trusts, using donor-advised funds, things like that too. And so, of course, it completely depends on, your goals that you have, the types of assets you have, because different types of assets can be used differently, like certain tools are best for, real estate versus stock versus company, things like that. And then, what you and your family want. So, and I think that's it. Hope I didn't bore you all too much on my tax chat.
I would like to say one thing. We all are very fortunate. I don't know how we would have survived had we not lived here. Everybody was wonderful, embracing, reaching out to us. I speak for several of us, I think. And we're so lucky. We're in a wonderful place.
Definitely, yeah. Vickers is so great. So
thank you very much.
You're welcome. Thank you for inviting me, and thanks everyone for having me. This is so fun. Turn that mic off. If anyone has any questions,